This is The Wrap on Aging, and I'm Rob Ence, your host with the Utah Commission on Aging, broadcasting from Scope Radio. The Wrap on Aging explains public policy, education, and research that informs and empowers Utah's older adults, and it connects you and your family to important resources and services. In 1936, George Kaufman and Moss Hart wrote the endearing and timeless play, You Can't Take It With You. It's a story about the eccentric and zany Sycamore and Vanderhoff household in New York City living life on their own terms, defining their happiness by choosing interesting and odd pursuits without regard to financial gain. They were living their version of the American dream. Their values reflected the reality that you really can't take it with you. So whether we amass a lot or a little wealth, none of it goes with us beyond the grave. At almost any stage during our lives, especially as older adults, taking account of what we want to have happen to us, our resources, our health care, our families, are all an important reflection of our values, yet they often go neglected as a planning priority. We should be asking ourselves, what are my values and priorities for end-of-life planning? What are my wishes for the disposition of assets? How do I want my personal medical care managed? Who gets to choose? How do I prevent the systems from acting on me? And what are the costs of my choices or the consequences of doing nothing? In this two-part podcast series, we're going to explore the legal and medical documents that will help us discover and organize the answer to these and other questions. We've asked two expert attorneys, each in private practice and experienced in estate planning and elder law matters, to join us for these two podcast sessions. Troy Wilson and Doug Cummings are here to help explain what these legal and medical documents are and why everyone should have them before the final curtain drops. Welcome, gentlemen.
Thank you.
Good afternoon.
In our first session, we will survey the variety of planning tools, what they are, why they are important, and what they are intended to do, and most importantly, how to implement them. In the second session, we'll focus more specifically on health and medical decision tools, and we'll be joined by a healthcare provider. So let me ask you, Troy, to start off here. Why is it important for people to plan?
Well, in my experience, I find that most people have some pretty specific ideas about what they want to happen at end of life or beyond end of life. And unless they can make those known and then also put in place the legal documents to make them happen, it's going to be left up to others to decide.
And so what are some of the consequences, Doug, when we do allow other people to make those decisions for us?
One potential consequence is that individuals surrounding the client, if you will, don't always agree on the same answer or the same solution. So you have disagreements, and that leads to fights and sometimes prolonged fights. Another consequence is that the individual's wishes are not followed because they're not known, and the information is learned after the fact, if you will, and so in most cases that may be too late.
So I would imagine in both of your practices that over time you've witnessed many situations where people wished they would have done things differently in terms of pre-planning because there become family squabbles or legal battles. I can imagine the cost and the heartache to a particular family is significant, Troy, when they don't do the planning.
It can be both emotionally and financially. And a lot of times those wishes come from not the people that should have planned because they're either incapacitated now or deceased, but from the family members who wish their parents would have planned and given them some more guidance. So I think one of the important byproducts of somebody doing their planning is to take that burden off of family members so they're not having to make decisions that they hope were what their parents wanted, for example.
So you introduced the thought that there are times when individuals become incapacitated. So you can have situations where people are fully capable and still don't make good decisions about their plan. But then you have the consequence of incapacitation, which sounds like to me it complicates dramatically the kinds of things that can happen to a family setting. What percentage would you say, Doug, of the population actually spends the time necessary to do these documents?
That's a good question, Rob, and I wish I knew the exact percentage. In my experience of over 25 years, what I would see is about a third of people actually take the time to put forth a plan that covers not only their assets, but also their medical treatment and end-of-life plan.
So one of the things we often say about physicians is that they may be their own worst caregivers. They don't take care of themselves. We want to ask attorneys, are you doing the things you need to do to put the legal documents in place for your personal affairs?
I do. I have a set, and I keep that up to date as well.
That's great. How about you, Troy?
Absolutely.
Yeah.
The cobbler has no shoes. I don't want to be that cobbler.
Exactly. We had a conversation, another podcast on emergency preparedness, and it was gratifying to hear that the individual interviewed was absolutely in place on all the preparations for food and water and emergency kinds of decisions. Well, these can also be emergency decisions. These are things we have to be prepared for because we don't know when something's going to occur that will either incapacitate us or cut our life short. Why do you think people procrastinate, Doug? What are some of the barriers to getting this work done?
Some barriers include, I would say, a family situation, especially in a blended family or a second marriage, something like that. Although in those situations, it's even more important to clearly set forth a plan to satisfy both sides of the family, if you will. Another reason is cost. And I think a human nature of thinking that it's not going to happen to me, so there's an automatic tendency to procrastinate, kick it down the road, so to speak.
So, Troy, what are some of the things you do to help people overcome the barriers to get their planning done?
Well, when we get involved, it's usually because some event has happened either in the person's life or in society. For example, right after 9/11, we had an uptick in calls because people realized how vulnerable they could be. The other thing that I find happening is when people have a new birth in the family or they have a new marriage and all of a sudden they have a new sense of responsibility. They'll call and want to start on their planning. Or common is, we're going on vacation next week. We need to get something in place now. And that's not always practical. But
right.
It's usually some kind of event like that that really motivates them to get started. And then we walk them through the process. And I think a lot of times people think it's going to be more painful than it is. People are reluctant to, reach out and contact an attorney because of historically what they've heard about attorneys. And I would say if you're dealing with a professional in a estate planning arena, we're typically a different type of attorney and not as scary as maybe people have learned.
So it would be gratifying to know that individuals who may be asked to take guardianship of children, that it's not a last-minute thought before people run off to vacation. Those are big, important decisions that people need to weigh. We've talked about costs. A lot of times individuals may take it upon themselves to say, well, I can go online. I can figure out what these documents are, and I can process my own. What are some of the pitfalls, Doug, would you say, in trying to do too much of this yourself?
One thing that occurs to me, Rob, is that you tend to find a one-shoe-fits-all solution if you do the online approach. And that's your own situation is anything but. By taking the time to work with an individual one-on-one to truly express your objectives and also your individual circumstances. And as I mentioned previously, say for instance, a blended family or adopted children or a special needs child, those circumstances require individual attention that I'm doubtful that you're going to find that to your satisfaction on an online approach.
Great. That's great advice. You are listening to the Rap on Aging podcast from Scope Radio. I'm your host, Rob Ence with the Utah Commission on Aging, and today we're talking about the legal and medical planning documents that everyone should have. My guests are elder law attorneys Troy Wilson and Doug Cummings. So we're going to talk a little bit about wills and trusts, but just as a broad overview, this question, Troy, are these documents that everybody should have and why?
I think they should, one or the other or both. At the outset, let's just understand that wills and trusts deal primarily with property. Anybody who has any kind of intent on what they want to have happen with their property needs to make that known, and they do that through legal documents such as a will and a trust. And the primary difference between the two is a trust can serve you during your lifetime, whereas a will is only effective at death. And I've heard Doug mention before that the will, in order to activate that, you have to go through probate, and he called probate the on button, which I really liked that analogy. A lot of people intend and wish to avoid probate, and they can do that through a trust. It's not necessarily appropriate for everyone, but this is going back to what Doug mentioned a minute ago, why it's important to have somebody who can interact with you, because you don't know what you don't know. And we'll have people come into the office that say, I want to avoid probate. And when we dig into why, we find out that maybe that's not as important as they originally thought.
So let's talk a little bit more in detail about wills, and then we'll come and talk about trusts. You mentioned a will triggers at the time of death, and there are other terms for that particular document. And I know a little later on we're going to talk about a different kind of concept that is often referred to as a living will. And so we want to distinguish, because those are things that actually go into place while you're alive, but it's another name for a healthcare power of attorney, I believe would be one way of putting it. So let's talk, where do wills come from, and why were they originally, am I taking you back to English law? Doug,
you are,
your
in
thoughts?
fact, yeah. The law of wills and probate in the United States traces its roots back to English common law, and it has to do with how the landowners would designate individuals to receive their land primarily. And in the United States, even today, dealing with land requires documents that are written. We refer to that as the statute of frauds. But you can see that the importance of that carries through to other assets that you may have. And when an individual dies, it's important to have in writing what would happen to land and other assets that the individual may own. Those are all brought together today and represented in the modern version of what we call the probate code. A will is a document that an individual signs today, and it does two things primarily. It appoints a person to be in charge of your affairs. In Utah, we refer to that as a personal representative. Another name for it is an executor. And that's a very traditional Hollywood term, if you will. The role of the executor is to carry out the instructions for what I call the inheritance plan. And the will would designate what that inheritance plan would consist of and designate the individuals to receive the assets, whether it's an individual asset for a certain person or whether it's a group of people sharing collectively what those assets may be, an equal share, if you will, of everything they may have. As Troy referenced earlier, a will is a game plan, and to make that game plan, to put it into effect, is submit it to probate court. Probate court is neither good or bad. I use the analogy, it's like my sandwich in my golf bag. I don't want to use it. I inevitably will, and I'm glad I have it when I go in the sand trap. But just because I have a sandwich, it's neither a good club or a bad club. Same with the probate. It's a tool that needs to be used if you rely upon a will, and there are some other reasons to go into probate to clear up your debts, for instance.
So the term probate comes from a Latin root to prove, does it not? Mm-hmm. And so you were basically proving that your claims are legitimate legal claims, or those who were presenting it to probate. But the idea of the will is to make that process smoother and to assure that your wishes and wills are carried out as you'd hoped. Is that
correct?
Fair?
Correct. Yeah, and probate is not just for wills. Probate can even be carried out without a will. But like you say, it's to prove what was intended. And that's why there's very strict statutory requirements to execute a will. For example, in Utah, we require 2 witnesses. Those witnesses have to meet certain conditions. And then we can have the will be what's called self-proved, so that those witnesses don't actually have to testify down the road, possibly.
So are these documents, are wills, because the code is unique to each state, correct?
Correct.
And so are they honored one state to another? Does somebody have to recreate a will if they move across state lines?
No. A will, because of constitutional rights and the relationship amongst the states, a will executed in Utah, according to Utah law, would be valid wherever the individual may reside at the time of their death.
So what are some of the other things that a will accomplish? Now, we talked about the importance of picking either a personal representative or executor, depending on the terminology used. What are some of the other key elements that need to be considered in a will?
A couple of things that you can include. For example, if you have minor children or a disabled child, then the will maker can nominate who they would want to carry on in that responsible position if they pass away. You can also express your interests on disposal of your body, whether you want to be cremated or have a burial service or there's a number of other options that are coming about nowadays.
So what are some of the more innovative ways wills are being used? I sense there's an opening there to something come to mind that.
Well, I've read recently about green burials, and then somebody mentioned to me just a week ago something about a liquid cremation.
Yes.
I haven't looked into that too much yet. I don't know if I want to, but interesting how things are changing.
Yeah, we all become little protoplasm or floating around in the universe somewhere, So let's turn our attention for just a few moments and talk about trusts. So let's start by just distinguishing a will from a trust, and then a couple of comments from each of you on the kinds of trusts and how people would use them.
When one creates a trust, they're creating an entity under the law. And a trust is created pursuant to an agreement that is prepared. And that agreement is essentially a set of instructions. The parties and participants to a trust consist of the individual who creates it. We refer to that as a grantor or as a creator, who designates a trustee, who's a manager and an administrator over the assets that are contributed to the trust. And the instructions that are referred to are literally delivered to the trustee, and the trustee needs to follow those instructions as stated in the trust agreement. And the next individuals participating in a trust are beneficiaries. And if I use the analogy that the trustee is in charge of the checkbook, the beneficiaries get the check. So the beneficiaries get the use and enjoyment and the benefit of the assets that are in the trust. Now, another element to a trust is that it's flexible, and you can provide different instructions that apply at different periods of time. As indicated earlier, a trust has effect during lifetime. So in my case, I set up a trust where I've named myself as the trustee. So Doug's the trustee. I'm also the beneficiary while I'm alive. I call that phase 1 of the trust. Phase 2 would be upon my death, and I would specify what do I want to occur with the assets and what instructions I would give to the assets when I pass away. In my case, I've specified that my assets will go to my wife so that she can continue with her life and help out our children and so forth. And phase 2 would end when she passes away, and then we've decided on an inheritance plan together to benefit our children, and that would be phase 3. And that's just an illustration of the differences that you can have with a trust. And I think that's one of the main distinctions between a will and a trust. So a trust is more specifically crafted to one's own individual circumstances. And especially when you look at the other issues that an individual may be involved with. And we've mentioned special needs childs, for instance, that a trust is often tailored to provide for that special needs child and to look at their individual circumstances and the resources that may be needed for the rest of his or her life.
So let's explore. I know there are multiple kinds of trusts, and it sounds like you've described a little bit what we'd call maybe a revocable trust where you control it. And then there's another kind of trust, Troy, and then probably several, but at least the irrevocable trust where you actually set that up for maybe a different reason and transfer assets in there, but there's a strategy behind what that is. Can you share with why somebody would want to do that?
Yeah, you opened that door. We need another hour or two.
Yes, I'm sure.
Like what Doug mentioned and you already referred to as a traditional revocable trust. When you start dealing with irrevocable trusts, it's a trust you put in place that cannot be changed. And typically the reason for that will be either tax reasons or maybe spendthrift reasons. There's a whole myriad of reasons. He referred to one. For example, special needs trusts. If you have a disabled child or person, and then there are different branches of that as well. But if with a disabled person, you want to be able to preserve their ability to receive benefits from state programs, then they can still have some assets protected in a special needs trust and yet also receive benefits. Other types of trusts are designed to get assets out of your estate for tax purposes or other purposes. In Utah, we're one of the few domestic asset protection trust states that also involves an irrevocable trust. So trusts, the beauty about trusts is they're custom. And this goes back to your question about why not just pull one off the shelf at the office supply store or one of the will programs, because they are custom and they really need to be designed for your needs and to meet the purposes you set out to have met. And you may not even know the questions to ask to begin with.
So part of having good legal counsel is to help discover what a person's true desires are, what effect they want it to have, what they're trying to protect themselves against, or what they want to have managed. And those are really hard decisions if you don't have the background to understand the implications of those decisions. If you're giving up complete control of an asset, it's very different than something you're managing for yourself or for your family that you want to determine its destiny for as long as you can. What are the liability protections of one trust versus another? I'm assuming you don't have an impenetrable shell with a revocable trust, but there are some protections with an irrevocable trust. Doug?
There are, Rob. You're correct that a revocable trust or revocable trust, there's not a whole lot of liability or asset protection or a shield, if you will. It's because as a trust that I create, I control the ability to amend it, and that means I'm basically controlling the assets as well as the beneficiaries. On an irrevocable trust, however, the rules are set, and only under special circumstances could that trust be amended, and that's pursuant to statutory provisions. And that means that the protection is much higher. And specifically, as you look at an asset protection trust, and as long as you're consistent with the statutory requirements of that trust, then the assets in that trust are protected, and they are unlikely to be taken by third parties or creditors or things of that sort. That's another reason to work with a professional so that you get the customization and the type of trust that you're interested in specifically.
So in order for these trusts to take effect, individuals literally have to transfer ownership to the trust. Is that a process that's intimidating to some folks, or is that a pretty easy transfer? Troy?
It's pretty easy for us, but it really depends on the person. So, for example, sketching a picture of a tree can be very easy for some people. For me, that's a different story. So it really depends on your mindset. We have clients that before we finish the process of drafting the trust, they're ready to go and transfer their assets in. Others we've found it takes 6 months or longer to get assets trusted in, and yet others will have clients come in and hire us to probate an estate because their assets never did get transferred into a trust. So it kind of runs the gamut. It's not difficult at its core, but I find that sometimes if people are a little intimidated by it or they don't understand the process, then they can defer it. They put it on the back burner and don't get around to it. And part of our process and our goal is to help people kind of bring that down to easy to understand and easy to implement.
Yeah, we mentioned earlier that the will is a very practical tool for almost everybody to express their wishes. A trust, we're talking more about assets and management of assets. Is there, in your mind, Doug, a threshold that justifies the creation of a trust, or can it be argued that even with minimal assets, there are advantages? I
agree that a trust can be suited for any given circumstances, Rob. It depends on what those circumstances are. It's not strictly asset-based. It's oftentimes situational based. So we refer to having a disabled child, blended family. There may be assets that require the management of a trust. They may be heirloomed assets, unique characteristic assets, for instance. So it's not just the value of the assets. But because many people tend to have that outlook of quantification of everything, I would say that an individual, a married couple, for instance, they have a home, they have retirement assets, they have assets for a rainy day, they may have recreational property. Something along those lines definitely would be a candidate for a trust.
Thanks for clarifying that we're not just about assets. Troy.
Yeah, and I think going along with what Doug said, 10 years ago, the criteria was very largely tax-driven. The estate tax laws have changed significantly, so that has taken that out of the picture a bit. But like he said, very, very individualized reasons to do a trust. For example, if you have a child who has substance abuse problems, it might be funded with minimal assets, but it's so critical that those assets be protected for that child that while a cursory review on Google might indicate that with the amount of assets you have, it doesn't justify a trust, in that situation, it could be absolutely critical to that child to have a trust to protect the inheritance and not enable them to do damage to themselves.
And so you can also restrict not only who gets it, but how it gets used.
Absolutely.
How it gets used, who's in charge of applying those rules, and so forth.
You're listening to the Rap on Aging podcast from Scope Radio. I'm your host, Rob Ence, with the Utah Commission on Aging, and today we're talking about the legal and medical planning documents that everyone should have. If you have any questions about this issue or suggestions on topics you'd like to talk to us about, please send us an email to utahaging@gmail.com, and be sure to check out our website at www.ucoa.utah.edu and follow us on Facebook. My guests are elder law attorneys Troy Wilson and Doug Cummings. Let's talk about some other special documents that often accompany the wills and trusts and what their applications are. So, Doug, what is a power of attorney?
Power of attorney is a document in which an individual, a principal, would designate another, known as an agent, and define the scope of authority, the list of responsibilities, where the agent would be authorized to operate. It's often used in it's used for many circumstances, but it's often used in the event of a disability, severe illness, an accident, where you have someone, where you've taken the time to appoint someone to be your agent so that when you're not able to take care of your business matters, as I've outlined, the agent is able to do so. Another context of the power of attorney is to fill a vacancy, either in time or in space. For instance, if you're going out of town and there's a piece of business to be accomplished, maybe a purchase of a piece of real estate, for instance, you can sign a power of attorney, appoint another person to actually finish the transaction for you, and the business is accomplished, and the property is purchased, and you're not even in the room because the agent, as you've outlined in your power of attorney, has completed that business for you.
So you actually have a range of powers of attorney, from very general and broad to very specific or limited. Is that correct, Troy?
Correct. Yeah. At its core, a power of attorney is just assigning somebody else to act on your behalf. It doesn't need to only be when you cannot act. It could also be when you choose not to act. For example, companies hire agents all the time to go and take care of various business. But in the situation that you're talking about, it can be as limited or as broad as you want. If you want to hire a power of attorney simply to manage a rental property for you, you can do that. Or you can hire an all-encompassing full-scope agent under a very broad power of attorney to do anything that you could do. File your tax returns, pick up your kids from school, any number of things.
So essentially, a power of attorney, the individual who represents you or the agent becomes you in that circumstance. And so this seems to me to be something you have to be extremely careful who you pick to make those decisions for you. I imagine you have both witnessed circumstances where an agent for a power of attorney has gone wrong. What do people need to be aware of in making that decision to choose an agent? Troy?
I think a couple of things. One of the issues that we deal with, for example, on the Commission on Aging, is financial exploitation of seniors. And one of the highest abuse rates is performed by agents who are acting under a power of attorney. So first and foremost, you need to be able to trust the person that you're designating as your agent, not just in a power of attorney, but also in a trust if you're choosing a successor trustee. But then second, you need to understand and make sure they understand your values and what's important to you and how they should act if you can't. Because like you said, they're stepping in your place. They're acting on your behalf, ideally as if you would act.
So there are circumstances then where you don't actually or cannot make the choice of who has that legal decision-making power for you because of incapacitation or something else. So what happens in situations where there has to be a legal intervention to determine who is going to be appointed to care for an individual's decisions?
What you're referring to is the need for someone to act on your behalf where you haven't already designated it.
Correct.
In that arrangement, with a power of attorney, for instance. That situation would be a court matter, and there are two topics that are addressed in this circumstance, Rob. The first of which is a guardian. A guardian is what I call a substitute parent or a substitute adult that handles the individual and the person of the individual, just making decisions similar to that a parent would make for a child about where they live, medical care, medical treatment, circumstances like that. The other position is a conservator, and a conservator is responsible for financial affairs, including any income that would be received or any assets that would be owned. In both cases, the guardian and the conservator is appointed by a judge, and this is another function of the probate court. And so the paperwork submitted to the court would be to describe the individual of the person, the protected person that needs the conservator or needs the guardian, as well as the individual that would be appointed the guardian and the conservator. Now, as to who that guardian would be, or who the conservator would be, if it's not in writing as a nomination, then the priority for that position would be determined by state statute. And generally, it's the nearest living relative, a spouse, a child, a parent, someone that's the nearest living relative for that protected person. Beyond that, then it'd be up to the court to determine, based on the facts and circumstances, why an individual, or in some cases a company, would be appointed as the guardian or conservator for that protected person.
So, Troy, a moment ago you mentioned some of the work of the commission involved in financial exploitation. And elder fraud, elder abuse is a real concern. What advice would you give someone who is wanting to trust somebody else to help manage their financial affairs? There's a tendency to trust to the point where we go beyond delegation, that we actually abdicate that responsibility. What would you suggest an individual do to make sure that those individuals are performing in the way they have promised they would?
It's difficult because once you're incapacitated and you're no longer really able to follow up on that, you're really trusting that person that you've designated. And so there's no way to follow up. But beforehand, when you're doing your due diligence and trying to decide who to appoint for that, for sure, at least look at the obvious things like, have they had a bankruptcy? Have they been able to manage their own finances? You're going to be trusting somebody to manage your finances if you can't. And if they can't even manage their own, that's usually a red flag. So there's certain signs you can look at. If they have a history of convictions of fraud or different kind of theft, type of charges, those aren't going to be the right person to appoint, even though they may be your oldest child or somebody that you think you may have no other choice if you've only got one child, for example. So there are professionals that can do this. Of course, they charge a fee, and a lot of clients don't want to go that route. But I think you can only do what you can do, but at a minimum, at least ask some of those basic questions before you appoint somebody, and make sure they have the same kind of value system as you have.
Yep, those are all good words of advice. And here again, you have to plan in advance. If you ever become incapacitated, that window of opportunity is kind of closed, isn't it? I would hope that we would encourage individuals to follow up, to not just trust, but to verify again and again to make sure that those wishes, where possible, are being followed. And I think another thing, and you alluded to this, is having individuals who don't have a stake in the game, that they have a conflict of interest, not necessarily directly, but could be over time in terms of how it impacts them or what they might get out of the decisions that they make. And you want somebody who is going to be independent and carry the fiduciary responsibility with integrity.
And don't be afraid to change your decisions too. Most of these documents we're talking about are not irrevocable; they're revocable. So if you get additional information down the road, make a change.
You're listening to the Rap on Aging podcast from Scope Radio. I'm your host, Rob Ence, with the Utah Commission on Aging. And today, we are talking about the legal and medical planning documents that everyone should have. My guests are elder law attorneys Troy Wilson and Doug Cummings. So in this last segment for this podcast, let's talk a little bit about other support documents and designations that can assist in the estate transition process. We talked a little bit before in the trust and making designate. The word beneficiary came up about designations. Now, beneficiaries show up a lot in other legal documents like insurance contracts, retirement plans. Let's talk a little bit, Doug, about what those beneficiary designations mean, how important it is to make the right ones, and what is the effective law of a designated beneficiary.
Let me do this by giving some context with the other documents that we've talked about. A will is a document that specifies an inheritance plan when you pass away. The go switch, as I said, is the probate court. A trust has different phases with it as far as the beneficiaries and who receives the assets of the trust or the use of the assets of the trust over time, during my lifetime, during my wife's lifetime, and then an inheritance plan for our children. In each of those cases, the assets are owned by the trust, or in the case of the will, it's owned by the individual. In the context of a beneficiary designation, a person can be designated to receive the asset that's not owned by, even though the asset may be owned by myself or owned by my trust. The beneficiary designation is basically a contract where I've specified upon a certain event, my death, so-and-so and so forth would receive this asset. And as you mentioned, Rob, a very common example of that beneficiary designation is life insurance. And I think most people are pretty familiar with life insurance, where the insurance is paid out upon the death of a certain person, and other individuals are the insurance beneficiaries. Another context of the insurance designation would be retirement funds, 401ks, and IRAs. And often, to be frank, bank accounts. Many banks are offering to their clients what they call a pay-on-death account or a pay-on-death designation, where any account at that bank could have a designation where a specific beneficiary or individuals would be named as beneficiaries for those accounts. The effect of that designation then is to have less of a reliance upon a will or upon a trust. And again, this underscores the reasoning to have one-on-one contact with an expert so that they know the circumstances and know what arrangements can be dealt with, made with your assets.
So there are times when beneficiaries can be changed, and other times when, in order to change your beneficiary, you have to have the permission of a beneficiary, particularly if it's a retirement fund and it's a spouse that's a designated. You had some additional comments on that, Troy.
I was just going to say the beauty of a beneficiary is it bypasses the trust, the will. It bypasses all those legal processes. It sends your asset directly to the named beneficiary. And that's ignoring the concept that a beneficiary can be named as a trust. A trust can be named as a beneficiary. But it's sometimes I've heard it referred to as a poor man's estate plan, because if somebody only has a couple of accounts and they designate the beneficiary and they have no other asset that needs to be probated, at their death, it would go right to those people. What it doesn't do is it doesn't accomplish anything if they're incapacitated. So you could end up back in court for a conservatorship like Doug talked about if that were to be needed. As far as the revocability, almost always a beneficiary is revocable. The exception in Utah and many states is under the pension laws. And a lot of people will have 401ks and retirement plans. Because it's in the state's interest to not have spouses disinherit their spouses, they require a spouse to sign off if you want to name somebody other than your spouse as a beneficiary on your retirement plan.
And I also understand, even if you want to borrow against that 401k, that if your spouse is one of the designated beneficiaries, that spouse has to sign off on the allowance to even make a loan because it protects the asset, as you suggested.
Correct.
Now, there are other forms of ownership that can assist in facilitating, or not, I'd hate to say the word avoiding probate, but that's kind of what's said.
That's a reference that's used.
Yeah. So joint ownership of assets for bank accounts and things like that, automobiles. Talk a little bit more, Doug, about how those joint ownership arrangements work.
That's a good topic, Rob. Most often in real estate, with the married individuals, real estate would be owned joint tenancy with rights of survivorship. And what that means is the individual dies, then the real estate is owned by the surviving individual. That concept is applied to many different assets, and you indicated some. Bank accounts, other financial assets would have common ownership of two or more people. And as long as it has the right designation, and this is where a legal technicality, but it's very important, the designation needs to be rights of survivorship, a joint tenancy with rights of survivorship. If you have that arrangement or that designation on your asset, then when someone dies, the asset's owned by those that are living.
So again, those designations are unique to a particular asset in a family situation, and I would assume also states, because some states operate under different, some are common law, and what's the tenants in common? I'm not sure exactly what the terms are. Go ahead, Troy.
Yeah, separate property law. One word of caution on joint tenancy, because a lot of times people will say, well, gee, that sounds pretty slick. I'll just name my kids as joint tenants on my house. Then when I die, they get the house, it's all done. Something to be aware of, there are certain tax consequences that are negative, and there are also potential asset protection consequences. So, for example, if one of their children were to be sued and an asset search were conducted and they see that this child owns an equity interest in this house that is not their house, potentially that could be attached. And so while it's an easy way to accomplish an asset transfer, it may not be the ideal way in a lot of circumstances, and it certainly has some risks with it.
So essentially, you're giving up control again, and you may be putting assets at risk unwittingly. And this goes back to planning and thinking out very carefully who you're selecting to be your partner in these particular assets, correct?
I agree with that.
Mm-hmm.
So there are a couple of other items that occasionally surface. A letter of intent that may accompany a will or a document. Now, I don't think it has the effect of law, but what are some of the advantages of an individual creating a letter of intent for his or her heirs?
Let me give you my experience on using or being familiar with a letter of intent. And I've had experience in this in the context of dealing with special needs children. And this is where a parent would, as part of their estate plan, write a letter of intent or really a letter of instruction on what their child needs, the programs they may be involved in, the exact medical situation and mental situation and the struggles that they have, and frankly, what solutions they've found. They've passed it on to someone else that's going to be presumably taking care of that child. And another context, though, for the letter of intent is having to do with how should I say this? Avoiding family struggles over heirloom assets. This document is, in a way, a part of the will, where an individual can designate where assets would go and specific persons to receive assets. And I'm familiar with clients that would specify instructions or requirements of receiving the asset, and that could be viewed as a letter of intent. And so in some cases, especially in the context of a will, it could be legally binding, and in a sense it's a formation of a trust, if you want to know the legal analysis behind it, because they're putting conditions on the use and enjoyment of that asset.
There is another document that sometimes is included in the portfolio of recommended documents for planning, and that is a HIPAA release. And HIPAA, for those who, it's a familiar term, but it stands for the Health Insurance Portability and Accountability Act. And we're going to talk more about the medical implications of that in our next segment. But Troy, if you could just comment a little bit about what that release is intended to do.
That's to allow people who you care about and who care about you to get information about your medical condition, to be able to pull medical records. So, for example, if you have a power of attorney that only becomes effective if you become incapacitated, you better give those agents the means to discuss with the doctors your capacity issues. Lately, since this act went into place, medical providers have been very, very strict, and it's largely due to the high penalties if they breach the act. So they've been very strict about who they'll share information with. And I've heard of situations as simple as somebody calling to check on their father at a hospital after an accident and see how he's doing, and he can't find anything out. if you can put on your HIPAA authorization who you're allowed to share information with, that can be a blanket authorization form for any medical provider in the future that may have you in their facility and allow your cared ones to get information about you.
So we've talked a great deal now about a variety of documents, but in order for these to have effect, there has to be awareness that they exist. They need to be stored in a certain way, available and accessible. So in a wrap-up comment or two from each of you, anything else you'd like to say about these things, but also address the fact of what is an individual's responsibility to make sure that these documents are kept current and that they are accessible when needed?
These are very important documents, as you can tell from our discussion, and they're unique, or they should be unique to your circumstances. Even though many people have the same and similar circumstances when you really think about it. That said, one thing that I would recommend is to have these documents available. Part of your important papers that you keep at your house. I've never recommended putting them in a safety deposit box. As a general rule, they have a tendency to be signed and sealed and then put in a file drawer anyway. And yet in a safety deposit box, they're inaccessible to anyone that doesn't have their name on the safety deposit box. And so they're really out of reach for people. More to the point, though, that these documents should be kept up to date because of the changing circumstances. I call that the changing landscape. And we've made reference of it here during their conversation. When you have a life event, which is a birth, death, marriage, divorce, to either you or a member of your family or people that are important to you, those circumstances and those events have an impact upon what you want to do. And if your documents are available to you in your house, you're more likely to keep them up. And I recommend that people look at their documents every year, and particularly when there's a life event that occurs. And when circumstances change, your documents may also need to be changed as well.
I'm really glad you mentioned life events. I'm an empty nester. My kids are gone. They've got their own kids. I got lots of grandkids. I don't think I've changed those documents since those kids are in the house. Now, that's a horrible admission, so I've got some work to do. Troy, final comments.
Everybody, I think, needs these documents. And while some people may like surprises, I don't think they like the surprise that they've been nominated. So I would say discuss this with people. Won't your children be surprised to find out that they now have a guardian appointed for them, even though they're an adult, right? Anyway, so discuss with your fiduciaries and your agents that you're going to be depending on and get their permission to include them in this. And so it's not sprung on them. The other thing I would say is technology can solve some of these problems in the sense of making these readily available. There are online cloud services available to make documents readily accessible through an ID card. And because by pretty much any medical institution, when you check in for an emergency procedure, they'll hand you a blank document to fill out, which is a medical power of attorney or a living will. And if you already have one filled out that you've been thoughtful about and sat down with professional counsel, you might as well use that one than fill it out under duress and under those emergency circumstances. So make them available, keep them up to date. Like Doug mentioned, he mentioned a lot of life-triggering events. Those are all critical. Even if you don't require a change, at least revisit it and in the context of what just happened, and then decide if you need to change or not.
Thank you for that. That's again, it's been a great conversation. I appreciate Doug Cummings and Troy Wilson for spending time with us, and looking forward to our next conversation. We appreciate our guests' time and their expertise, and we thank all of you for listening. Please join us for a continuation of this topic on our next podcast. None of us are getting out of here alive. If you have any questions about this issue or suggestions on topics you'd like to talk to us about, please send us an email to utahaging@gmail.com, and be sure to check out our website at www.ucoa.utah.edu and follow us on Facebook. I'm Rob Ence, Executive Director of the Utah Commission on Aging, and this has been The Wrap on Aging.